Oh, shit. Here we go again.
Hey, now.
We're just getting started. I know that you want it.
This is a certified hood classic.
All rise, orders, accord. Delaney is here, and a quote from your savior.
That's right. The savior of the masses. Why not kick off on Monday with a beautiful quote from a true icon,
a legend in his own right,
in his own mind.
Right. Yes.
Hopefully, everybody had a great weekend. Creed. Judge Simpson had a rough week last week.
Oh no.
And, you know, I picked out 3 plums from last week that he just, you know, he just had a rough time with. I figured, why not just, if we can't make him happy, how about we make ourselves happy by watching him be pissed off at people?
You know how I made myself happy?
Uh-oh. Go ahead.
It's Monday morning. Nothing about that. Have you ever had goldfish in a tiny little package? Little packages of goldfish. Have you seen those by any chance?
Kind of like the ones they give you if you're on the airplane.
Yes, like that. We were at a restaurant and it came to the kids' meal, and of course they didn't even. I think she just opened them up, just laid them there, never even touched them. They are the best tasting. It goes along with the the crackers,
and the small bottles of ketchup and things like that.
Exactly. Yes. So we just found them Emily just found a box of 30 of them at Target for $10. So we're gonna try them. I swear to God, better than even flavor blasted goldfish. They had a little salt on the top. They tasted like cheddar cheese. It's amazing.
I wonder why, though. I mean,
I don't know.
Is it because it's just a smaller quantity? And
I don't know. I don't get it. But those are ideally some of the best that we've ever had. Kind of like I just had one of the best BLTs I've ever had for the cookout.
Oh, cookout BLTs are good.
Yeah. I'm kind of disappointed the chicken tenders that I get. It's the only place I get chicken tenders is there. They're balls now. It's like the 3rd time. Like Deborah, chicken tenders flat. No, they like ball them up and then throw them in the fryer now. You get 3 of them. It's the 3rd time.
Chicken balls.
Disgusting. They're just like chicken balls. Anyways, happy Monday. The J is for justice, and let's do it. I'm ready.
Let's roll on into it, shall we?
In regard to counsel. State your parent.
Good morning, Your Honor. Tiffany Hughes, P79762.
All right. Ms. Hughes, and just so that we're clear on
this
the record.
This is an attorney that's in trouble.
I was hearing which was set by the court regarding your failure to appear for Mr. Slater's
life-changing case
preliminary examination. I further indicated to you that it was troublesome for the court that this got set, and that at the time that it was set,
welcome, Dustin.
The court is aware that.
Good to see you, Dustin. Thank you. Welcome.
You knew that you had taken employment elsewhere, and that Mr. Slater appeared for a preliminary examination.
The attorney took a job somewhere else and left dude hanging and didn't show up for court.
No,
it's pretty bad when your lawyer don't show up and you're like, I don't know where she at. Judge Simpson is not going to look too kindly on this. Jiggy.
In fact, I won't say without counsel, but without counsel that was ready to proceed regarding his statutory right to have that hearing. Further,
beautiful hair.
That ultimately the court was also informed, at least by Mr. Slater, that he had not been communicated with by you except for the initial time, had not been communicated about your impending departure when he then appeared before the court. Since that time, I will also indicate to you that because of this, and I'm only dealing with the Slater matter, but there were other instances during the same time, one being in 15th District Court, and I believe one being downtown before the Circuit Court, where you were counsel of record and did not appear for those proceedings. I will say also specifically regarding this proceeding that on the date and time set for the preliminary examination that this court through my office tried to contact you numerous different ways, and we did not receive a response. The ultimate
Oh, wow.
thing in that is that Mr. Slater's preliminary examination, which I believe was ultimately waived, but he did not have his preliminary examination, and his proceeding was delayed by, I believe, approximately 2 weeks. So the court has issued the show cause to see why the court should not hold you in contempt and issue sanctions.
So, Your Honor, I did inform special, like the people that assigned me the case, I did inform them and I let them know what case I had outstanding. I was then contacted by the attorney that would be subbing in for me, and I gave him all of the information. I sent it to an email as soon as he contacted me. It was almost simultaneous. So,
but what day was that?
the day it was, so they contacted me, the sub attorney, they contacted me on March 8th, and I sent it on March 8th.
Yeah, he did.
Substitution attorney was Bernstein.
Yes.
Bears.
And I sent him all of the discovery, everything that I had on Slater.
From that
Saved
one
by the Bell.
And beforehand, I went to the special counsel office and I just gave them a list of everything that I had outstanding.
But counsel, that your obligations under the court rule are to still appear. I mean, because the preliminary examination said that was on the March 8th. That was a Friday. Preliminary examination was set for that Tuesday.
Sorry, Your Honor, she was busy partying with Mikey on his birthday the day before.
You know, you gotta do something. You gotta do something.
This is an interesting one. I don't think we've ever seen this play out.
Yeah, we on the channel we did have when she wasn't there, and the guy was like, "I don't know where she's at," and they're like, "Can you get up with her?" And then you can hear him, "Yeah, I called her. Nobody can get up with her." I don't know where she's at." You know, they're trying not to talk on the mic, and you can hear them.
Right.
Okay, all right, somebody better find her. And eventually, she did come in, and he set this for this date. But she is definitely not going to take the L on this. She is fighting this all the way.
Yeah, she is.
For Mr. Slater. And Mr. Slater had not been informed when you were doing all of this.
Nice.
And then I spoke with his mother and I informed her, and then I gave her the new attorney's information with Mr. Slater's mother.
Why would on February 29th, you have set this for preliminary examination when you knew that you would not be counsel, that you had accepted other employment?
I thought that another counsel would sub in for me in time. Because like I said, I informed special counsel who assigns this, I informed them, so I thought that another
On what
attorney-
day did you inform them?
This was February 22nd, I believe. February 22nd, I believe.
Thank you.
Then why
Twinsies.
do I not receive a motion to withdraw until March 11th?
I don't know, Your Honor.
2 days before my
Well,
birthday.
you're the one, counsel, you can't just say I don't know because you're the one responsible to withdraw from the case. Regardless of the fact that the MAC office is the one that gives your name, it is your obligation. It's not their obligation. You would agree with that. I mean, you're the attorney of record.
Understandable.
Is she just picking at her nails or
If
something
you
right now?
Knew
I thought she was
on the
doing something.
22nd of February that you were going to be withdrawing from cases. I don't, on this matter,
Yes.
I don't get anything until March.
My apologies. I didn't know. Like they said they
Sorry.
did all the motions to withdraw for me, so I thought they would have got it sooner. I did inform them February 22nd, and I thought that substitution counsel would be in before then.
Ms. Hughes, if that's true, then why on February 29th, this would have been a week after, do you appear and set the case for preliminary examination
because I thought
and not inform the court, not inform the defendant, not inform anybody that you won't be
Music, thank you for the tree fitting. Appreciate you.
I'm not gonna tell nobody nothing, nowhere, no how.
No.
They'll figure it out when I don't show up.
She got excuses.
She
I don't think
does.
any of them are really hitting. Well, she didn't do that much anyway.
Told his mama. I slipped a note under the door.
Right.
counsel of record.
again, I thought that it would be substitution counsel. So I really thought that it would be a counsel would be substituted in, and that's
That doesn't even make any sense, Ms. Hughes. If on the 22nd of February, you know, and you say you informed them of that, you appear on the 29th of February, do not do anything to withdraw, do not do anything to place your client in a position where they're not worse off. You indeed, what you do is you set him for preliminary examination at a time you know you're not going to be counsel. So that doesn't even make what you're telling me doesn't make any sense. So why didn't you do something on the 29th?
okay. I was still trying to get all of my other ones in order, not just this court, but just all of the other courts that I was trying to tie up those, and ball got dropped.
Nice laugh.
It doesn't make any sense to me, Ms. Hughes. I want to give you the benefit of the doubt on this.
Anybody who says that the YouTube algorithm is broken, just look at Loud's comment.
Yeah.
They nailed it. That's funny. Casey Carey and all of you. This Monday Express. Thank you guys. Appreciate it a ton. And
She's trying to get out of this. I don't know if I'd want this lady as my attorney.
I don't think so either.
But if you're telling me on the 22nd of February that you knew that you had other employment, that you informed, you're saying at that time, without turning this into a full-blown hearing, but I'll bring them down, that on the 22nd, that you informed the MAC office.
We do that on Tuesdays and Thursdays of each week.
Appeared then on Mr. Slater's case on the 29th.
Except for vacation. Then and it might have a date night Thursday with the wife. So it might just be Tuesday this weekend. We'll see.
Wow.
Yeah, it's been a few years. Figured why not?
Splurge.
Set it for a preliminary examination. Say nothing to the court, nothing to Mr. Slater or anyone that you will not be the one handling the preliminary examination. You are still the attorney of record. The 12th comes along because that's the date it got set for. For March 12th, you do not appear on March 12th. We sent you various communications during that day. You didn't appear before the court on the 12th.
Kirna, thank you for the $2. By the way, what does Charlene Wagner do? She was banned and her comments were removed. Charlene Wagner.
I ain't got time for all this. This commentary is really useless.
Oh, well,
so
you're a
what?
useless viewer, so goodbye.
Oh, yeah. Goodbye. I ain't
Sit
got
by
time for
yourself,
this.
watch a video by yourself without 240 people enjoying. Poor Charlene doesn't understand how the world works. Charlene's one of those people that look up in the sky and see one of those SpaceX things going by and going, what the hell is this? I'm going to post it all over the internet and ask if anybody else saw this. I've noticed a lot of that lately.
Ain't nobody got time for that, Charlene.
Poor Charlene.
Oh, and just did nothing. In fact, counsel, you don't know on the 12th that other counsel has been appointed to represent him.
I did know on the 12th. I sent the other counsel the info on the 8th.
Oh, I'm going to really piss off Charlene now. Gary, yeah, so if you ever want your boy him to win, just let Creed see the car beforehand. That's kind of cool, though. We were at Joe Gibbs. That is the winning car.
That's right. Creed lays hands on the car. Next
That's right.
thing you
From
know,
afar.
it's a winner.
Window. And what happened? I thought that was kind of neat, though. We got to see the car before they even released it, and I got in trouble on Reddit because I put the picture up and they had not released the new look of the car yet. So removed my post.
So it was my understanding that was his other counsel. If he communicated to me and asked me for the discovery,
You are not released from an obligation until the court releases you. You do know that, don't you?
yes, and I thought that with him calling me and informing me that I was released. My apologies, the ball got dropped.
The ball didn't get dropped. I don't have an order even to sign if I wanted to.
Yeah.
But I don't even get an order to me that I eventually signed
Yeah, watch out.
until
It's Monday.
which
Too
is
early in the week.
your
for that
obligation
shit,
to
right?
withdraw, not the MAC office obligation to withdraw. I don't get an order until the 12th, the date of his prelim. And then they have to adjourn the proceeding out. Anything else you want to say?
No,
What happened? It got dark the other day, Steve.
And Ms.
Dark
Hughes,
for
I'm just
anybody
gonna
else?
let you know, I don't appreciate also that when my staff reaches out to you, when this court reaches out to you, irrespective of anybody else, we got no response from you. None. We sent emails, we made phone calls,
I didn't get a phone call.
we
You sure you called my phone? Because there's no
Yeah.
missed calls.
response. Anything else you want to pay? I was trying to find a way where this was not something that I should sanction misuse, but I don't see that. Anything else you want to say?
It is not. She
Nothing
didn't
further.
I'm
show
going to
off.
sanction you to $500.
500 bones.
That's to be paid to the court. When can you get that paid to the court?
In about 2 months.
Pardon?
I'm gonna need about 2 months.
What?
What?
You're a lawyer? And you
That's
need
something I can pay online or
What?
We'll have to ask the clerks up front.
She doesn't have $500. Really?
I even have $500 to pay right now.
I
if
can
I
put
needed
that
to.
together, man.
Like I
June
might need
21st.
to borrow for some, but still I could get it together. Like yeah,
Yeah.
like I could get
I can get it together,
I
sure.
mean,
But you're an attorney.
Jesus
You're telling
Christ.
me you're not making enough money to break with $500? And he was kind of shocked that she said, I'm going to need about 2 months to pay that. Can I pay that online? She's turned into one of her clients automatically.
Whoa. Okay.
Unbelievable.
Damn, she's not even like, maybe if she was like in a really expensive city, I'd say, all right, so this lawyer's making good money, probably living a bit above her means, up in a high rise, that kind of. Oh my God,
Makes you wonder what she's doing with her money.
Yeah, good Lord, we the people welcome. 2 months for $500. How about $50 payments? 10 months, $50 payments.
How much can you put down today? Nothing.
Oh, you're not missing anything. Mikey just asked somebody so fast I didn't even get to see why or how, and he don't even watch the comments.
I ain't got time for that.
Not today.
Not today. Man,
You what?
unbelievable. I can't believe that.
Part of it. I don't think they've bet their burden.
I know.
They certainly have put on evidence that the weapon was stolen, but we don't know when that weapon was stolen.
A stolen pew.
We don't know the circumstances. And you're wondering why that's important. Why
That's a good point. That had nothing to do about the money. It's just like I think you're right about that. Mayor, thank you. Could you imagine? I'd be embarrassed.
Yeah, why you want to go in there and piss off the judge?
that matters.
Well, I'm wondering why you're saying that to me. I mean, if it were stolen 10 years ago as opposed to the day before, will it matter for me?
It would, because the
Okay.
prosecution would certainly jump up and argue that if it were just recently stolen, that he would obviously have some sort of that would obviously mean he had some knowledge it was stolen, because recent possession would sort of point to that.
Oh, I see.
So I'm taking that argument out of their mouths. They have to be able to show that he had some knowledge that the weapon was stolen. So what do they have? He paid a lot for it. That means he knew it was stolen. I think even at a probable cause level, that's a stretch. Because basically, I can tell you this, I'm not a weapons guy. I don't know what one pays for weapons. If someone wanted to sell me a weapon and said it's 150.
Well, I am, and I think probably
Well, yeah,
50 was too high. But
all right, you are. But we don't have any evidence that he is. There's no evidence here that he would know that. And so if you're going to try to argue, oh, well, he paid too much, that means he knows it was stolen. Well, you have to show that he would have known that. You have to show that he would have had that knowledge. If that's going to be your argument for knowledge that he knew the weapon was stolen, and they have to put on something that tells you that he knew the weapon was stolen. So what I'm doing here is I'm trying to take those arguments out of their mouths. That's exactly what I'm doing here. The argument that recent possession of something that was recently stolen might lead to an inference that he knew it was stolen. The idea that because he paid so much or a particular price for a weapon, that he must have known it was stolen, without showing that he's the knowledgeable person about what weapons would cost. And you have to set aside your knowledge on it. You have to do that.
All right. So the only thing that I can say is it's not a baseball card. You can't go back to Beckett right back in the day and look at a book and say this should be this on, you know what I mean? So
Right.
I understand what he's trying to say, but at the same time, if it's $1,000 pew and you buy it for $100, you should know better. I think is kind of what they're getting.
But again, it goes back to the point of you don't know somebody's situation. Maybe you owe the court $500 and you need to get the money quick. You're selling a pew that's worth more.
That's possible.
To get that 500 bones. Get
Yeah.
it together. He
Right.
needs to get together some money, maybe. You never know why somebody becomes desperate to sell something.
It's very true. There's a reason for everything, and it's not always that it's stolen. However, you should be careful.
Yeah, you got to be
When it comes to pew-pews and such.
I certainly can set aside my knowledge, but I'm just saying, I mean, there's other indicia. The fact it wasn't registered, I mean,
Okay.
because it wouldn't have come back stolen if it had been. That's the reason I can say.
Well, yeah, okay. Well, I'm not arguing that the weapon wasn't stolen, but I'm arguing that they haven't shown that he knew it was stolen. I'm arguing that they haven't shown anything that says he had the knowledge that this is a stolen weapon. Okay, so it wasn't registered. All right. So how long had he had the weapon? We don't know that. There's no evidence to say how long he had it. There's no evidence to say that he didn't just pick up that weapon the day before and maybe it was going to register if he thought he could. None of that's there. buying a weapon doesn't, even if you buy it under illicit means, doesn't mean that you know it's stolen.
And I just to some of the comments, I understand it's a bit of a gray area here, and you can't. I think what they're saying is that they're using that as like evidence, basically, that he knew that it was stolen. You see what I'm saying? Just because of the price, and that's a little. I don't know if I agree with that 100%.
That he should have known it was stolen because of the price. Again,
Right.
you don't know why somebody's trying to get rid of something. I mean, he could have known 100% it was stolen. Not saying he didn't.
Right.
But like his defense is saying, we don't know. You know, we don't know that he has knowledge of what it's worth. You just like going out and say, hey, a car pulls up in front of my house and he says, I want $500 for this car. I don't know if this car's worth $500. I couldn't tell you right off the top of my head. So again, you don't know the circumstances. The guy needs $500. His mom's sick, whatever. There's so many factors that go into why somebody would sell something at that price.
And for you to pin that on him because you think that he should know that. I mean, again, we're in court. Let's not forget we're in court. Yes, every day, listen, you're watching Cops or Live PD, whatever. And somebody makes that excuse. Okay, but we're in court, and if you're using that as like a base set, it's a little stretching it a little bit. So I don't blame him saying what he's saying.
It just means you bought it illicit. It means you bought something you shouldn't have bought. That doesn't mean that it's stolen. Okay. So the bottom line is, Your Honor, they do have to put on some evidence, or some evidence from which it could be reasonably and logically inferred.
That's a good point, though, Griggsy. But they're supposed to have very stringent. I know, like, they're supposed to hold things for like 30, 60, 90 days, something like that.
Mm-hmm.
And anything that has serial numbers and things like that are always cross-referenced with the local cop shops, if I'm not mistaken. I don't think so.
Let's remember that Bishop had an entire arsenal stolen from his home.
And by the way, right? Wasn't that within like a few days of moving in?
A few days of moving into his new home. And the ATF got up with him like a year or so ago because some of the guns had popped back up. They weren't going to give them to him, but they were trying to identify the guns and make sure those were the guns. He still didn't get the guns back, but they're still floating out there. So there's they're trying to regulate, they're trying to keep everything together. And when you go to a pawn shop, they are really eventually going to catch anybody taking anything stolen, like a gun in there.
Yeah, if I was going to buy something like that, I think I'd try the most direct route. I don't think I'd be trying to save money. I don't know. I'm sure a lot of you have bought pew-pews from other people. I don't know. No, I do like his question. I don't think that if you buy what Griggsy asked is, if you buy a stolen anything, say from a pawn shop, should you be charged with it? I don't think so. You try to go through. I mean, listen, if you go to the flea market and buy from somebody, well, that's a little. If you're buying from a legal business,
knowledge of the nature of this weapon, that it was in fact a stolen weapon. None of that is here. You can talk about all you want. Well, he shouldn't have paid as much as it was such an ugly weapon. Why would he pay that much? Or it wasn't registered. Those things don't matter if they don't show that this person, this individual, had knowledge that this was a stolen weapon. Could have been something somebody found, somebody tossed away. Could have been.
But it's knowledge or reason to know.
All right. Well,
right. And
so all right. I love that.
Wouldn't that really be an issue of fact?
No.
Given all the circumstances?
No, and no, because they have to put on some evidence from which you can infer that element. They have to put on evidence of all the elements. And the necessary element here is that he should have known or had a reason to know it was stolen. None of the things that they talk about will lead to that conclusion. None of the evidence they put on will lead to the conclusion that this individual, knew or should have known this was a stolen weapon. He might have known that he bought it illicitly. He might have known that he shouldn't have a weapon. But none of that says that he knew that this particular weapon.
We'll turn on you in time, don't worry.
And that's what they have to show. They're going to say that he should be bound over on receiving and concealing a stolen weapon. That particular knowledge. And it's just not there.
Right.
So as to the others,
Yes.
carrying concealed weapon, possession by a felon, I think those are actually issues for the trial. But the one is not an issue because they haven't made an issue because they have not put in sufficient evidence for you to logically infer that he had knowledge that this was a stolen weapon.
Thank you, Your Honor. When we were here on April 2nd, 2024, Trooper Chowdhury testified. During his testimony, I admitted the defendant's admission to Trooper Chowdhury. Trooper Chowdhury testified that the defendant told him that he had purchased the firearm 2 days prior and that he had purchased the firearm from somebody by the name of Jay, that he wouldn't provide any further details of who Jay was or the information
Some good
about the sale.
under there, you know.
So when I layered that prior testimony on top of today, defendant was too much, $225 for a high point, and that the high point was in poor condition, in this painted condition, and that it's returned stolen. I do certainly have at least a probable cause and a question for the jury as to whether or not this defendant knew or had reason to know that this firearm was stolen.
Kind of not wanting to get Jay in trouble for an illicit weapons sale. It's not knowledge that it was stolen. That's a huge.
What's a huge leap? Was some guy named Jay sold an overpriced weapon to somebody? That's a huge leap as to whether or not I know it's stolen.
Exactly right. So maybe he knows he's not supposed to have a weapon. Doesn't mean he knows it's stolen. Again, he's not trying to bring everybody else down with him.
Thank you, Mr. Brown. Having heard all the testimony, and as to count one, certainly the people who have sustained their burden, and the court would find the defendant overstand charge trial on count one. As to count two, there's been much talk about the receiving and concealing and the defendant's knowledge of that. There is certainly, people haven't shown his direct knowledge necessarily. There is certainly evidence by which a fact finder could infer that the defendant had knowledge. One, the purchase of a firearm at an amount, by the testimony of Mr. Spencer, at an amount more than really twice what he paid, what he would have paid for that same weapon, having knowledge of that weapon. The fact that there's an admission that he purchased it from some guy named Jay 2 days prior. The weapon is not registered, so it comes back stolen. All of those things, I think, can be used to, at least by a fact finder, to infer that the defendant had some knowledge that this was indeed a stolen weapon. So for those reasons, the court would find that the people have indeed sustained their burden as to count two and would bind the defendant over on that charge also.
Yeah.
Well, there it is. Bring Jay into court right now.
With the addition of the April 22nd to 23rd day.
There's no way to presentation information. My client was still in there.
Defendant having
Jesus Christ, what are you guys
Great
talking about in
reading
chat today?
presentation.
I have no
Well,
idea.
there is not guilty plea as to both counts. Pre-trial in this matter will be set for
Good God.
At 1:30 before Judge Kunke.
June 4th, 2024, 1:30.
Right?
In front of Judge Clunky. Reminds me of the robot from Pee-wee's Playhouse. Clunky.
The bond violation. They were sentencing on the violation. Did you get the new report?
Yes, I did, Your Honor.
Is there anything you want to say before I?
Yes. But I'd like to start off. Ms. Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow. And she admitted
About the
when
what?
presented to her. There was a delay for the tether, which I believe is what you're
A
referencing.
dirty blow? Is that what she just said for the dirty blow? Is that what she said?
I've heard of dropping dirty, you know, if your urine test is bad, but she did a dirty blow.
Did say dirty blow. My God, what happened? Everything was going good for the first 30 minutes of today.
Somebody comes in and says
And
how
then-
nice everybody is. Next thing you know,
Yeah.
everything's gone crazy. I'm hitting
Yeah.
buttons.
Well, everybody's heard
I mean-
about the bird.
I mean, it's a dirty blow. She's doing the
Wow.
dirty blow. So I'm guessing she's got the little, you know, device.
It's not just the chat down below, it's also that board that's getting us going. Yeah, I thought I did. Mikey kind of did chuckle a little.
I was
bit,
like,
did
did
I
she just-
hear that right?
I was like, I don't know what. Look, I blame myself as well.
Holy shit! All right,
dirty blow.
I'm gonna bag that up just a couple minutes here, and we'll. Jesus Christ!
She's probably on sober link.
22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow, and she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th. She
I'm sorry that Charlene didn't hang around and.
She really would have. She really, missed out.
It really did. It all went down very. Like I said, first half an hour, freaking perfect today. We were doing so good, Tom. We were doing so good.
We were on top of things. We were acting professional, and next thing you know, dirty blow.
Shit, and then Ragu Monkey shows up on Monday. Shut up, Mikey. Today.
Dirty blow around where he lives is way different, but
did
we won't even
go
talk about that.
Community corrections, but because she had her child with her, community corrections
During a dirty blow?
not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now, so she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She has worked full-time, been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So
Isn't everybody a full-time mother if they got kids?
On bond
Think
while this
so?
case is pending.
That's how that works?
Taking time off, kids.
Anything from the people.
We leave it on the court's discretion.
Oh,
The problem that I have,
Hey now.
Wilson, is that on the 17th, you admitted to the violations. We set the sentencing out to today. In the interim, because there was a dirty blow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday, that you put yourself onto a scram tether.
busy judge.
Trying to figure out why.
Yeah. I worked both.
What'd you say?
I work Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad. Or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, I'll watch it.
Hey, how I know that you weren't drinking over the week.
Take my word.
I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober one, right? The alleged blood alcohol content was 0.085. There was an accident.
It was an accident.
During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow.
I'm gonna
I
clip that.
should have sent you to jail that day, and I didn't do it. And I didn't do it, giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said because I got the tether.
Oh, I know.
Oh.
5 days late. So
You need a grace period.
I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober link either.
Because the device locks. I didn't know if that was because
Because you were supposed to probably be on a scram.
And she did inform me of that. She did inform me of that yesterday when she tried to test on the sober link. On the 18th, it gave her an error that it had to be reset.
And you did nothing.
Bring my kid in there. I can't.
But you did nothing.
Awkward silence.
And then let me ask you this. Do you not take this seriously at all?
I do take it serious. I'm busy. I'm a very busy person.
Okay.
Oh, I got an answer for that. So SoberLink, through my research of SoberLink, the way it, it's just a handheld thing you take around, you blow in it when it's time to blow in it. And it has facial recognition software and has a little camera on it. So it sees who is doing the blowing.
Oh, damn.
So you can't cheat it. You can't cheat it because it looks at you and does facial recognition.
So there it is.
Pretty serious device.
We all are.
But it's kind of inconvenient for me.
Oh, Jesus.
Don't say that to the judge.
Jesus.
You had so much time to go. God.
That doesn't mean that I'm not doing anything. I've been coming to court
This is all inconvenient.
It's
all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient.
It's just real inconvenient, Judge.
She's very busy.
But if true,
2 days a week of work.
No one in this room is the cause of that inconvenience except you.
Yes. Look up at me, please.
Gotta have eye contact all times.
He's handling this very well, by the way. I would have freaked the F out right there with that one.
I think her use plays an age inside this. She's only 22. This is her first criminal case.
An adult for 4 years, according to the law.
This Friday.
So she's 21. This is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her.
But Ms. Coons, I appreciate that. But at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7.
Oh, yeah. Don't forget, as Too Sweet pointing out, she doesn't have a freaking license right now. Let's not forget that. How's the insurance looking, you think?
She's doing great. She's doing great.
8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Well, let's say 20 violations of basically, well, it's not quite that many. It's about 15 violations of the program itself in terms of when she was supposed to blow.
She missed blowing
And
15
on the
times.
next
Oh,
one,
wow.
she drank.
And then she blew dirty. Dirty blow.
Then, even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled.
Have we not seen people in court for missing one or two?
Oh, God, yes. Oh, God,
right?
yes. Yeah.
They'll haul you in like if you miss one or two.
A violation.
Yeah, and the receipts, and they'll go. So to miss that much,
she's on a roll. I mean, she really is.
She's doing great.
On the 12th, she didn't test on 2 occasions for her testing that day between 7 and 10 a.m. and 2 to 5 p.m. She didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then on that day still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month.
Oh, geez.
And then she appears before me on the 17th. I give her a break by not remanding her and tell her that she has to get a tether. And then I get here, I'm now, and set this out to the 24th, and now I get here and she's too busy and it's inconvenient. Really?
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just,
Yeah.
I don't get frustrated.
Yeah. Well, she does have the tether on, so it would negate any further missed test, Your Honor.
Remember the tether
She'd be able
test.
to
is just
continue on
wet.
time.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But she, when we spoke,
Mr. Allen.
she stated that she'd like to continue this case. She'd like to stay out in bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed a court date.
Again.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests.
I can't give the attorney a lot of crap when you're trying to defend things like this with a straight face to the judge with a straight face. I don't know how they do it.
I believe her name is Miss Kuhn. Miss Kuhn has, she's always dealt with some really rough cases and tough times, and she's doing her best. But she is not helping herself at all with all these.
It's almost better just to shut up and not. But then you're not really doing your job because you're there to try and. I couldn't do it with a straight face. I couldn't.
You miss going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I have a choice.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th. You didn't do it. In fact, so that we're also clear on the 19th.
She didn't need her kid to blow.
On the 18th, community corrections talked to you that day.
Mm-hmm.
And you told them that you would report to them on the 19th.
Yes, because I thought I could, but I couldn't.
That's a Friday.
Mhm.
And you didn't report on the 19th. You didn't call to reschedule or offer to them, according to this report, any explanation for you not reporting. You just didn't show up.
Good point.
And then on Monday, even if I accept your rationale that you were working and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't. Monday, you weren't working.
You're right, Griggsy. Here's a perfect spot for her just to say, break down and say, yeah, I need help. I drink. Can't help it. Can't keep my shit together.
Mm-hmm.
You're
But
absolutely
she's
right.
got nothing but excuses.
Yeah. Well, those are people that are not ready for the help.
Again, remember, it's not just that she didn't go get the tether on like she was supposed to and waited X amount of days to finally go get it on. She also missed 17 times of blowing in the old blowy, and then she does it and she blows dirty. It's a lot of things. It isn't just that one thing. It's all of it. All of it.
Don't forget, she is very busy.
And you still didn't go until late, actually, after the agent that's assigned to your case at Community Corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether. Because otherwise you'd be showing up today with no tether. And mind you, the person that did that did it after the agent that's assigned to your case had terminated you from community correction supervision because you weren't compliant. Anything else?
No further.
Lady, you're going to have to learn to just pay attention. When court tells you to do something, you're going to have to do it. This isn't all about you. Everybody has busy lives. And I can appreciate it when I see people try. What I see in this report is somebody that's not trying. That somebody is putting other priorities ahead of what your obligation to this court is and what your obligation to this case is. And again, allegedly, you made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident. It's the sentence of the court. Defendant remanded to the Washtenaw County Jail to serve 5 days for the violation.
5, not even 3, 5.
5 days.
I think
5
that's good.
big ones. That's good. That's what she needs.
Absolutely. I absolutely think so. I think that is good. It's going to make her. She's going to think. She's going to think about that.
Yeah, and she again. Otherwise, it's going to be excuse after excuse after excuse. She just can't stop. I mean, apparently, maybe that's the way she's lived her life so far, and it's time to change it.
It sounds like she had plenty of chances, plenty of time to get in there and get that done. I mean, that's a court-ordered thing. You can't mess around with that.
Yeah. And again, remember, it's not just that one thing. It's all of it together. It's a complete mess.
I actually think he could have given her more there. I think.
Absolutely.
5 was a little lenient.
If she hadn't had a child, probably would have got more, to be honest with you. People play that off very well. Sometimes they use it as an excuse. And again, that's what she did the whole time. She had an excuse for everything.
Yep. Lots of excuses today. We've noticed throughout our court time.
Something that there's no excuse for, though, Creed. We're going to have a premiere happening in just about an hour. You'll be redirected there, no matter where you're at. It's Judge Middleton from today, Creed.
Hey, now.
He got pretty upset with a guy. He got pretty heated.
Ruh-roh.
And he's under the weather, so that doesn't help.
He
either.
is?
Yeah.
Was he sick or did he go on vacation? What was it?
I don't know, because there was other people in the courtroom that were not seem like they may be getting over something as well. But it's not too often when Middleton looks at somebody and says, "You're a thief and a liar."
Oh, nice.
So some Middleton, some really good stuff here of a guy that was stealing scrap metal and decided to steal a lot of stuff other than scrap metal. So,
oh boy,
you don't want to miss it.
It's a Monday Express. Tiny Piggy was first today, first of the week. Look at you, Fletcher boy. Thank you. Music makes you lose control. Up here. KC Masterpiece. That's pretty good barbecue sauce, by the way. Kirnoff, OJ, yeah, Wonder Twin, Double D's, and Hubby Sup.
Sup,
Mayor, fan of the year, Flusha, King of the Dirty Blow. Thank you guys so much. Appreciate it. Nice to be back in court for the whole week.
Yeah, great to see a bunch of new people. Make sure you've subscribed, when you're there. Well, Charlene, she's probably a super fan. She doesn't want to admit it. She don't want to come out and say it. Don't forget 405 Mini Chase Monday. We got some really, really good stuff lined up for that. A chase. We're going to kick the show off with a chase from South Carolina, Creed's own backyard.
Mount up.
So get ready for that. Much more. I
And
love
then,
you.
Members only, 5:30.
Yeah, we got a Chase channel. We're gonna see a lady get pew-pewed over alcohol.
What a great
A beautiful segue, right? This lady probably could have used it too. You guys do me a huge favor. Like the video if you haven't done so. Subscribe wherever you're watching. Go back and watch some old videos. Drop a comment. I'd love to hear what you got to say about that, unless it's some bullshit like Charlene had. Stay safe, stay hard, stay tuned. We'll see you on the next one. Bye. That's right. Don't let her spoil your fun.
Bye for now. Bye, Eileen.
Act